5 seconds. Start. The above referred paragraphs of the written statement do not amount to a clear and unambiguous admission, full stop. The defendant had relied upon the terms and conditions of goods receipt, issuance of which he admitted and stated that in fact and in law there is no liability upon the defendant to pay the claimed amount, full stop. The preliminary objection taken in the written statement in regard to non-joinder of parties as well as the suit being frivolous would go to the very origin of the case if the defendant is able to prove these issues during the course of trial, full stop. A plea was also taken that the defendant had not acted in accordance with the provisions of the Carriers Act and no notice had been served, full stop. In the written statement, even receipt of the notice was disputed, full stop. Written statement has to be read and construed as a composite document, and the court cannot pick up a single line and treat it as an admission out of the context in which the line is written, full stop. The learned counsel appearing for the appellant contended that there was no privity of contact between the truck owner and the plaintiff, and therefore there is no occasion to imply the said party, full stop. There is the question which could only be decided after the parties had led evidence, and the court still had to examine as to what will be the effect of the preliminary objection taken by the defendant in their written statement, full stop. It is impermissible in law that only a line from the written statement could be taken, and even the entire para in which the line is written is ignored in its totality, full stop. What the defendant has stated is that the goods were loaded to the truck, but the goods were not traceable, full stop. What was stated in the same paragraph was that as per the terms and conditions part of the goods receipt, there was no liability upon the carrier to make good the loss, full stop. This was a question of law which required adjudication, and the defendant was entitled to an opportunity to prove his pleaded case, full stop. This was certainly not a question where the court could decree the suit by treating the above paragraph of the written statement as admission which is unambiguous, clear, and admits the claim of the plaintiff, full stop. During the course of hearing, it was brought to the